Hello, good to be with you. My name is Anthony Guettler. I'm a partner with Gould, Cooksey, Fennell, and I'll be speaking with you today on Florida Community Property Trusts, saving tax and avoiding pitfalls. Today we're going to cover Florida Community Property Trust. I've got it broken down into, 5 different segments. Essentially, we're going to go through a refresher on community property for those of you who aren't familiar with that. We're going to talk about Florida Community Property Trusts and community property trusts generally. We're going to talk about the income tax planning opportunities with these trusts. We're going to work through some examples. We're also going to talk about the advantages and the best use cases for Florida Community Property Trusts. We're then going to get into some of the pitfalls and tax issues that can come up with these trusts. And finally, we're going to go through some of the materials that I've provided to clients in the past and walk through some of the issues and documentation that would be needed to do this kind of planning. What is a Florida Community Property Trust? Well, it's a specialized kind of joint trust established by married couples, and it meets the requirements of the Florida Community Property Trust Act. These types of trusts, community property trusts and common law jurisdictions, are not new. Florida's has been around for about 5 years now, and Alaska has had its community property trust legislation in place since 1998. What is community property? Well, it's a term used to describe the rights that couples have in their property, rights of divorce, rights of death. There is no uniform definition of community property. It essentially varies from state to state, so there's a lot of differences between community property jurisdictions. However, there are some common elements, and probably the most important for our discussion today is that community property is a 50-50 situation. It's not a 60-40 or anything like that. If the marriage is terminated in the event of death or divorce, there's going to be a division of the community property trust assets 50-50. How is community property created? Well, if the couple's living in a community property jurisdiction, then by default, under the laws of that state, the rights that they have in their property that they acquire while they're married will be community property. If the couple's living in a common law state, like Florida, for example, and that state allows for community property within the confines of a community property trust, then that's how it's created in those states. And, in Florida, for example, we can't have community property existing outside of a Florida community property trust unless it's community property that's been imported from a community property jurisdiction. Which brings up another question. What if a couple moves here to Florida from a community property jurisdiction? What happens to their property? What do we call it? What rights are maintained? Whose laws govern how the income's divided, what the creditor rights are? Those are just some of the open issues that come up when you have this situation. But what we do know is that certain rights that couples have when they move to Florida from a community property jurisdiction are protected. And that is the rights of death. On the death of the first spouse, any property that's brought into Florida from a community property jurisdiction is going to be owned by the deceased spouse's estate, 1/2, and the surviving spouse, 1/2. Now, why is it important to know about community property? Well, first off, more than a quarter of the U.S. population lives in a community property jurisdiction. And next, these couples are moving to Florida as much as any state. And community property states are actually, losing population in that respect. Florida is one of the fastest growing states in the U.S. Also, it's important to know about community property because the legal and the tax attributes of community property are very different than what we're used to here in Florida. And to give a couple examples, the first would be ownership. Ownership and titling of assets does not control when it comes to community property. For example, if an individual owns a bank account that was acquired in a community property jurisdiction like California, for example, and then they move to Florida and then that individual dies, the account, 1/2 of that account is part of the probate estate and 1/2 of that account is going to be owned by the surviving spouse. That's just one example. There's many more differences, including tax planning with community property. Anytime you're going to make gifts or do tax planning with property that's been brought into Florida from a community property jurisdiction or property that's traceable to that community property, you need to be very careful and understand the differences that as compared to property acquired in Florida. Okay, what other states have community property? Well, essentially it's the westernmost states, and they're all essentially connected. You see them here on the slides, less Oregon and then less Wisconsin, which is disconnected, but it's also a community property jurisdiction. So there's 9 US states that are true community property jurisdictions. There's also 5 states that allow the creation of new community property, even though they're common law states. Alaska, Tennessee, South Dakota, Kentucky, and most recent, Florida. And Florida has had this ability since 2021. There's also 16 states, Florida being one of them, that formally recognize the rights at death that spouses have in property that's brought into Florida from a community property jurisdiction. So Florida has the Florida Uniform Disposition of Community Property Rights at Death Act to protect the rights of married couples that they have in their property brought into Florida at death. All right, what's the main reason to be talking about, thinking about, learning about community property trusts? Well, it's income tax savings for the surviving spouse. This is a real opportunity in some cases. And here's how it works. With a Florida Community Property Trust, half of the trust is going to be included in the deceased spouse's gross estate. However, both halves of the trust are going to receive a step up in basis under Code Provision 1014B6. And that's how community property works. That's also known as the double step up in basis and can eliminate significant gain on appreciated assets for married couples. Let's look at an example. Example number 1, business owner clients. Couple starts a new business, they invest in their business, they put in $1 million, let's say. And then let's say there's 100 shares outstanding. So each spouse owns 50 shares, each with a basis of 500,000 and fair market value, in our case, of $8 million. So we're going to assume the business appreciates in value. And then let's say one spouse dies and the surviving spouse comes to you and says, now that my spouse has been laid to rest, it's time to kick back, life's short, I want to sell the business. And you would explain to them, okay, if you sell the business, you're going to have to think about capital gains. And in your case, the shares that you have continue to have a $500,000 basis, but the shares that you inherited from your deceased spouse will have a $4 million basis because that was the fair market value on the date of death of the spouse. So collectively, the surviving spouse has a $4.5 million basis and property worth $8 million. So there would be a $3.5 million capital gain if the surviving spouse were to sell the business. Compare that to a Florida Community Property Trust. If all the shares had been owned by a community property trust, not only would the one half that was the deceased spouse's one half have received that step up in basis, but the surviving spouse's one half would have also received a step up in basis. And there would be 0 income tax due on the sale of the business by the surviving spouse. So that's a compelling opportunity for couples. Another really good use case for Florida community property trusts would be Florida homestead. Florida homestead is an attractive asset because it tends to go up in value. So we're seeing a lot of clients with highly appreciated Florida real estate. Also, Florida homestead is protected from creditors, and it continues to be protected from creditors inside of the Florida Community Property Trust. So that is one downside of these trusts, is that they do not have protection from creditor claims, but with the Florida homestead, it continues to be off limits for creditors, which makes it an attractive asset. So again, probably one of the best use cases for Florida Community Property Trust, we're talking a married couple, stable marriage, older, so one or more of the spouses is close to death and close to this step up in basis, highly appreciated Florida homestead, and a spouse that would likely sell or at least consider selling and moving, downsizing, whatever the situation is. that's probably your best use case. If that couple were to have a home, let's say worth $5 million and a $1 million basis, the tax savings alone to the surviving spouse, if they were to sell the house, would be $500,000. So that is significant. Note here, one of the, I wanted to, there's a few situations where Florida Community Property Trusts probably aren't the best planning. And that would be for younger couples with a long life expectancy. They're so far away from this basis adjustment at death, it may not be worth the risks that we're going to get into. Also, if spouses are, on the rocks, so to speak, in terms of their marriage, that this may not be the best strategy. And finally, if you've got, couples that really want to protect their assets from creditor claims, a Florida Community Property Trust has a number of shortfalls, and there are better options under Florida law. So clearly, Florida Community Property Trust can save a lot of tax for the surviving spouse after the death of the first spouse. And we just covered, quickly a couple of examples in ways that can happen. But we glossed over a lot of detail, and we did not get into some of the complexities, some of the pitfalls that you're going to face when you do this sort of planning. So let's start looking at that. But before we do that, let's fully kind of build out the advantages of community property trusts, and then we'll get to the more interesting part. So as I mentioned, main benefit is income tax saving. Appreciated property owned by the trust is going to receive a step up in basis under 1014B6, at least we think. We'll talk about later, there is some tax risk with this strategy, and the IRS has not confirmed that this works for sure. But what's important to note here on the double step up in basis is that there are other alternatives to a Florida Community Property Trust for a couple in this situation. And I think your discussions with your clients would be incomplete without going into these other alternatives, other ways that the clients can eliminate gain and save income tax for the surviving spouse. So the first way would be to simply transfer the low basis assets from to the spouse with a shorter life expectancy. Or perhaps even better, maybe the spouse with a shorter life expectancy already owns the low basis assets, so they're just going to hang on to them. And then what happens? Well, when that spouse dies and they leave their assets to their surviving spouse, the assets received by the surviving spouse would receive a totally new stepped up in basis under Code Section 1014. And that strategy is tried and true, very simple, does not involve the complex valuation rules and the tax risks and uncertainties associated with Florida Community Property Trusts. So why aren't we all just doing that? Well, let's talk about that for a minute. There are some drawbacks to that planning. First is that the spouse we don't have a crystal ball. We don't know which spouse is actually going to die first. So that's the first risk. Second would be, if the moneyed spouse has all the assets, that spouse might be a little bit uncomfortable transferring all the assets to the other spouse in the hopes of receiving them back, after death. Now, perhaps they'd be just as uncomfortable with a Florida Community Property Trust once you explain how that works in the event of divorce and death. But that's definitely part of the dynamics of the relationship between couples that need to be worked through. Finally, if the transfers between spouses aren't completed at least 1 year before death, and the highly appreciated assets are just transferred right back to the spouse that had them in the first place, there won't be a step up in basis under the Internal Revenue Code. Code Section 1014E would prevent a step up in basis because that happened too close to death. The transfer to the decedent spouse would have had to happen at least 1 year before that spouse's death. Note, however, if the assets were being directed to children or trust for children, then there can be a deathbed transfer between spouses, full step up in basis, and transfer to children. 1014E does not apply in that situation. Also note that if the assets weren't devised directly back to the spouse, maybe a trust that the spouse had some sort of interest in, it's also possible that at least a portion of the assets would receive a step up in basis, even if that occurred those transfers occurred within 1 year of death. Alternative number two to the basis planning that you do with community property trusts would be upstream basis planning. And this kind of planning can actually be done for married couples or single individuals in the right situation. Individuals with appreciated property, trustworthy family members that have a modest estate, no creditor claims, and are open to this sort of thing. There can be strategies that essentially involve a transfer to the family member with a short life expectancy, and then transfer back to the individual that had the assets in the first place. And this can be done through trusts to protect the assets better and give more certainty that they'll be available to the individual, your client, that had the assets in the first place. But this line of planning is called upstream basis planning, and it can be highly effective. Another option, alternative to a Florida community property trust, would be a joint exempt step-up trust. This is a type of trust designed to achieve a full step-up in basis on the death of the first spouse. It uses different provisions of the Internal Revenue Code to do so, and the creators of those trusts are some really smart guys in Clearwater. Alan Gassman and Chris DiNicola have authored an article that compares that trust to a Florida community property trust, and that would be a good resource for you if you're interested. Okay, so advantages of a Florida community property trust. We talked about income tax planning, and we talked about some of the alternatives. Another really strong use case for Florida community property trusts would be clients moving to Florida from a community property jurisdiction, like California, Texas, some of these community property states in the US. Compared to more traditional means of preserving and protecting community property, a Florida community property trust has a number of significant advantages. Advantage number one, there will not be a need for complex and expensive tracing. So traditionally, when a couple moves here with community property from a community property jurisdiction, you as the advisor and or the client would need to be sure and segregate those assets and be able to prove that they were traceable to property acquired in the community property jurisdiction, so that they would be treated under Florida laws, community property, under our probate code, and also for federal tax purposes. So no tracing with Florida Community Property Trust. The other benefit would be you can use Florida homestead can actually be considered community property with a Florida Community Property Trust. That is not permitted under our Florida probate code with respect to imported community property. So major advantage there, especially if you've got a client with a highly appreciated homestead or homestead that may go up in value. Finally, another advantage of Florida community property trust planning versus traditional means of preserving community property from other jurisdictions would be arguably the Florida Community Property Trust has more support and has stronger arguments for the double step up in basis under 1014b6 than traditional means. And that can certainly be debated among tax professionals, but that definitely is a potential advantage. One thing that some commentators and those that are familiar with Florida Community Property Trust would say is a benefit would be simplification. But in my view, joint trusts are not simple. Community property is not a simple concept. There's a lot of nuances, a lot of technicalities, a lot of ways in which that planning can have unexpected results for the client. So simplification, bottom line, is not a benefit. Neither is expense. I don't think you're going to be saving expense with a Florida Community Property Trust, especially when you count the expense of the additional reporting and tracking and things you may have to do post-death to prove and show the double step up in basis. Okay, let's talk some now about pitfalls and tax issues associated with a Florida Community Property Trust. Number one, these trusts are not protected from creditor claims. So if asset protection is a high priority, then Florida Community Property Trusts may not be your best option. What you need to know here is that if there's any sort of joint claim against the spouses, all the assets of the trust will be subject to creditor claims, or if the claim is against one spouse, half the assets of the trust will be subject to creditor claims. Now, homestead excluded. That is going to be protected no matter what, whether or not it's in a Florida Community Property Trust. But compare that to other forms of joint ownership that are permitted under Florida law, like tenancy by the entirety's property, and you could have done a better job protecting your client's assets with those forms of ownership than you will with a Florida Community Property Trust. Now, side note, there is actually one case where a Florida Community Property Trust may provide stronger asset protection, and that is for couples moving to Florida with imported community property from a jurisdiction where all of the property is subject to creditor claims. If you're from a jurisdiction like that, for example, California, and if those rights govern the rights of creditors here in Florida after the move, then potentially the Florida Community Property Trust is better from a asset protection standpoint. What's another pitfall? Well, couples need to clearly understand what they're getting into with Florida Community Property Trust. This is a 50-50 situation. And if you've got couples that don't fully understand that, that can be an issue for you as the advisor. So if there is a death, if there is divorce, the assets inside the trust are going to be distributed one half to each spouse. That's not up for debate. That won't be, they won't be able to renegotiate, at the time of divorce. So it begs the question, can the couples get good advice on this trust structure from the same lawyer? Well, you definitely need to keep in mind, if you're a lawyer planning these transactions and representing married couples, your responsibilities under the rules of professional conduct and specifically Rule 4-1.7. You also should keep in mind that 50% of marriages roughly end in divorce. So if you're not talking with your clients about that possibility, you may not be giving them, the kind of advice they need. And so to comply with a lawyer's obligations under Rule 4-1.7, that lawyer is going to need to make sure that the clients are fully apprised of the pros, cons, risks, understand that they do not have to have a joint representation and that separate counsel might be best. And the lawyer is going to have to flag all the potential conflicts of interest and obtain that client's informed written consent. Okay, moving on to another potential pitfall, and that is the trust and protection for the surviving spouse. So I have been drinking the Kool-Aid here, and I am a totally believer in trusts and the protections that they can afford to the beneficiaries. And in this case would be the surviving spouse. So if first spouse dies and they leave their assets in trust for a surviving spouse, that trust can be protected from creditor claims, divorce, bankruptcy. It's a very good, situation. Now, with a Florida Community Property Trust, what you need to know is that only one half of those assets can be placed into a trust, a protected trust for the surviving spouse. So you're limited there. If the goal is to get all or almost all of the assets, it might be a missed opportunity with a Florida Community Property Trust. Also note that you really can't require a Florida Community Property Trust to be irrevocable as to the surviving spouse. Under Florida law, under the Florida Community Property Trust Act, the surviving spouse must maintain the ability to modify the trust and therefore could take out, all the assets that are the one half belonging to the surviving spouse. So there's not going to be creditor protection around the one half that belongs to the surviving spouse. Another downside would be the step down in basis for lost property. So this planning works brilliantly when you have appreciated property. But if the assets go down in value, or if for some reason, without advice of good counsel or good CPA, clients contribute assets that have a basis in excess of fair market value, on the death of the first spouse, both one halves of that property are going to be stepped down in basis. And the result will be more income tax for the surviving spouse. So bottom line here, you should not have lost properties owned by a Florida Community Property Trust. What's another potential pitfall? And that would be tax law changes. Tax laws change. That's just the way it is. And if the basis adjustment rules are changed to limit or prohibit altogether the basis adjustment that applies currently under current law at death, then potentially the clients have, wasted some time and effort setting up this trust, only to find out, later that the tax laws didn't stay in place that would allow them to take advantage of the double step up at death. Another issue is deathbed planning with these Florida community property trusts, funding them within 1 year of death. And how would this happen? So your clients come to you, they set up this trust, they fund the trust, and then one of the spouses dies inside of 1 year. It's possible that only one half of the assets will receive a step up in basis inside of the trust if one of the spouses dies within 1 year of death. And the analysis of how all that works, it depends on the terms of the trust, depends on which spouse owned the low basis asset, who made the contributions, and 1014E is going to govern that. And there are some uncertainties there. So we're not really sure what happens in all cases when there's a death that occurs within 1 year of funding of a Florida community property trust. So keep that in mind. Non-pro rata funding. All right. What do I even mean by that? I mean this. When I draft my Florida community property trust, I require that on the death of the first spouse, one half of the assets are going to be one half of each asset owned by the trust on the death of the first spouse is going to be distributed, half to the surviving spouse and half to the deceased spouse's estate. That's consistent with community property laws generally, but that's not required. Under the Florida Community Property Trust Act, the funding of each spouse's 50% share in the trust can be made on a non-pro rata basis. However, I would caution you in doing that. I would caution you and ask, warn you that you need to research what that would potentially ultimately do to your double step up in basis. Under 1014B6, there is a requirement that at least one half of the property be included in the deceased spouse's estate in order for 1014B6 to apply. The question becomes, does that code requirement apply to the trust, in which case you would get the double step up in basis even with non-pro rata funding, or does it apply on an asset by asset basis? And I don't know the answer to that question. So I would avoid it, and I would have my trust require that one half of each asset owned by the trust be distributed accordingly, half to the surviving spouse, half to the deceased spouse's estate. In addition, if I was advising a trustee how to administer one of these trusts, I would be very cautious in advising them to do a non-pro rata funding. For example, move all of the business assets to the deceased spouse's estate and all of the homestead to the surviving spouse, just because those assets are the same value, and technically you can meet the requirements of the act. That may cause issues under 1014B6 in qualifying for the double step up. Next issue, again, potential trap, tax issues that come up in funding. So this is, remember, a joint trust. Joint trusts are inherently complicated and come with tax issues. In fact, there are articles that have been written titled Tax Dangers of Joint Trust. And one of those would be a taxable gift at the time of funding. That is something you do not want to do for your client, particularly clients with a taxable estate. That'd be a waste of gift exemption to cause some sort of gift in connection with a transfer that benefits a living spouse. So to minimize those potential gift issues on funding and potential income tax issues on funding, I would recommend that the spouses plan on contributing identical assets to the Florida Community Property Trust. And if that requires an exchange of assets or division of assets or some, transaction between the spouses prior to funding, that be accomplished prior to funding. And that way, if there's a gift from one spouse to the other spouse, it's going to qualify for the federal gift tax marital deduction. Unless, of course, one of the spouses is not a U.S. citizen, then it would not qualify for the federal gift tax marital deduction, which would also be a bad result. So this kind of planning is specialized and really shouldn't be used for non-U.S. citizens. It also, in transferring and retitling the assets before they are contributed to the Florida Community Property Trust, it avoids any sort of income tax issues because transfers between spouses aren't going to trigger income or gains, and potentially that could be the case with a trust contribution, depending upon the asset, the liability of the asset, the terms of the trust. Also note that if the couple is transferring into a Florida Community Property Trust community property that's coming in from another community property jurisdiction, then it's going to already be identical and equal ownership, and the kind that's not going to cause gift issues. So you won't have to reshuffle in order to have identical contributions and identical funding if it's community property already from another jurisdiction. And the other thing I would do in drafting my trust, I would allow each spouse the ability to unilaterally revoke the trust without the consent of the other spouse. And that way, if there is any sort of gift because the spouses are different ages or for whatever reason they're making unequal gifts in funding the trust, those gifts should be incomplete because of those provisions. Again, the goal is to make sure we don't have a taxable gift in the funding of this joint trust. What's another issue to watch out for? Well, Florida Community Property Trust can own property anywhere in the U.S., anywhere in the world, actually. But if you're owning property that, for example, is real estate in another state, I think what you need to do for that to be considered Florida community property under our traditional conflicts of laws principles and things like that is to first contribute that non-Florida real estate and non-Florida personal property to a Florida LLC, and then contribute the Florida LLC to the Florida Community Property Trust. I think that's going to give you a better chance of the income tax result that you're looking for with these trusts and qualification under 1014B6 and this property being Florida community property, which is what we want. Which brings up another potential issue, and that is funding and planning with limited liability companies in connection with Florida Community Property Trusts. So what's important to know is when you have a limited liability company is whether that LLC is a single member or multi-member LLC. A multi-member LLC is going to be protected in some sense from creditor claims because their remedy is going to be limited to a charging order. A single member LLC will not be and is more accessible by a creditor. So, an open question here with these trusts is, what kind of an LLC do we have if all of the LLC is owned by the Florida Community Property Trust? Do we have a multi-member LLC that's protected from creditors through charging order, or do we have a single member LLC that's more accessible? We don't know the answer to that question. So if you're looking to answer that unanswered question, you need to have, let's say 5% of the LLC owned by each spouse, and then have 90% contributed to the Florida Community Property Trust. Another issue that comes up would be the taxation of the LLC when it's owned 100% by the Florida Community Property Trust. In that case, it's unclear whether the LLC is taxed as a disregarded entity or if it actually has two owners for federal income tax purposes so that it's a partnership and needs to file a partnership income tax return. So you're going to need to consult with your client's CPA to determine what's going to be the best position and most comfortable position for the client and the accountant for the client to take with respect to an LLC owned by the Florida Community Property Trust. Speaking of business entities and ownership, this would be another potential issue, potential trap. If your client is planning on contributing S corporation shares to a Florida Community Property Trust, you need to be very careful. You need to remember that not all trusts are qualified shareholders of S corporation stock. And, one of the most common exceptions to the prohibition on ownership of S corporation shares would be grantor trusts. Grantor trusts are permitted to be owners of an S corporation and will not disqualify the corporation from its S election. So is a Florida Community Property Trust a grantor trust? Well, if each spouse has the ability to revoke as I draft mine, then yes, there's some regulations on point that would confirm the Florida Community Property Trust is a grantor trust. After one spouse dies, that's a different situation. And again, that's where you're going to need to think through what the tax status is, where the shares are going to be transferred, what's the timing of that, and talk with your client's CPA, and to make sure those details are properly mapped out. What you don't want is to inadvertently terminate the S election of the corporation by transferring those shares to the Florida Community Property Trust. Another potential trap, clients may have an existing premarital or postnuptial agreement already in place before thinking about or planning with a Florida Community Property Trust. And if that's the case, you need to read those agreements. You need to make sure that the terms don't contradict themselves. You need to make sure that the establishment of community property is permitted under the agreements. So what you don't want to do here is a head in the sand approach. You need to find out if there's agreements, read them, and deal with them and figure out whether it's going to have an impact on your Florida Community Property Trust. Another issue and question I've been asked is if property comes out of the Florida Community Property Trust, what is it then? Is it community property? Does it convert to separate property? Well, the answer is it depends. If it was community property acquired from a community property jurisdiction prior to funding, then it should retain its status as community property under the laws and provisions of the original jurisdiction in which it was acquired. If it was separate property, and it was a Florida married couple client that contributed separate property to the Florida Community Property Trust, it should be separate property when it's coming back out. Now, as I mentioned before, there are gift tax traps in making gifts with community property. So if there is a concern about that, and if that keeps you up at night, it may be that you need to sever your property coming out of this Florida Community Property Trust if your client intends to turn around and make gifts of that property to a trust like a spousal lifetime access trust, for example. Another issue that comes up here is fractional interest discounts. So typically, let's say your client is a married couple living in Florida, and under our normal rules, if there's property that's owned jointly, like a house, then the value of the one half that is included in the deceased spouse's estate is pretty simple to determine. You just go get an appraisal of the house and you take 50% of the value, and that's what you can report on the client's federal estate tax return as the value of that deceased spouse's one half interest. Community property is not so simple. It requires not only a value of the entire house, but it will also require you to take into account that what's actually part of the deceased spouse's estate is a fractional interest in real estate, which means there should be discounts for the fact that it's a fractional interest in real estate, discounts because the property can be partitioned, and other factors that detract from value, which requires a special valuation, and that costs money. So make sure your clients are aware of that. All right, so we talked about Florida homestead and that being, one of the most compelling use cases for Florida community property trusts. So I want to spend a little time there so to help you better understand what the issues are and help you plan around them so you don't run into any issues with Florida homestead and Florida community property trusts. All right, so here's, I think, the best way to think of it, and let's just run through an example. So let's say we have a Florida community property trust that's set up by spouses, and the only asset in that trust is the Florida homestead. So on the death of the first spouse, there's two shares being established. One half of the Florida homestead is the property of the surviving spouse. Question is, is that a vesting of property under our Florida Constitution, or is that that's the surviving spouse's one half share? It's not a devise. We don't have to worry about much. I think that's the case, but I'm not sure. The concept of Florida community property and homestead is pretty new under Florida law. Traditionally, Florida homestead has been exempt, excluded from the probate code and the Florida Uniform Disposition of Community Property Rights at Death Act. So any imported community property that was invested in Florida homestead traditionally couldn't qualify. But under Florida Community Property Trust, we can have those two things, community property and Florida homestead. So again, I think with respect to the surviving spouse's one half share, we probably don't have an issue. But I'm not certain of that. All right, let's take the deceased spouse's one half share. So the deceased spouse's one half share for sure is going to be subject to the devise limitations under Florida law. And that means the deceased spouse's one half share, provided there's no minor children, may be devised to the surviving spouse outright free of trust. That's it. That's the only thing that's allowed. If there's minor children, then the deceased spouse's one half share is not subject to devise at all. And you've got a different result under Florida law, notwithstanding anything in the trust or otherwise. There simply can be no devise if the married couple has minor children. So please watch out for that issue. So what are the solutions here? Well, the one I like best is a waiver of homestead agreement. Spouses can waive their rights to homestead as surviving spouse under 732-702. So to not have an issue on the death of the first spouse with the devise of Florida homestead, I recommend a homestead waiver agreement. Now, keep in mind that needs to take, has the same formalities as a postnuptial agreement with the same financial disclosures. But that's how I set mine up. There's also the option of a waiver, Florida homestead devise limitation waiver that can be included in the deed that transfers the house into the Florida Community Property Trust. That's permitted under 732-7025. There's more than meets the eye there, and there's good materials that were written back in 2019 that flush out some of that planning and some of the issues with homestead waivers by deed. Another potential route would be if the Florida homestead was in an irrevocable trust that qualified as an irrevocable trust under 732-4172, then perhaps the Florida devise limitations don't apply. I say perhaps because remember, with a Florida Community Property Trust, the surviving spouse must have the ability to amend the trust and essentially revoke the trust. So I'm not sure if you can even qualify a Florida Community Property Trust as an irrevocable trust within the definition of the probate code that's necessary to avoid the devise limitations. Another option that I've heard talked about would be have the Florida homestead owned by an LLC and then have a 99-year lease with your clients. That might work. That sounds and is complicated on top of an already complicated structure. I don't think we're going to spend a lot of time on that planning. I tend to see that planning mostly with Cupert's Qualified Personal Residence Trust and the expiration at the end of the Cupert term and trying to preserve the homestead benefits for the surviving spouses. Excuse me, the spouses that no longer have access to the house after the Cupert term. Another solution would be to devise the entire homestead to the surviving spouse outright and free of trust upon termination of the Florida Community Property Trust. That should do it for sure. That should avoid the devise limitations on Florida homestead. And that is definitely an option as well. Okay, let's talk a minute about one other potential solution to the Florida devise issue that comes up when you have Florida homestead owned by a Florida Community Property Trust. And that is, as I mentioned before, it's not required that on the death of the first spouse, one half of each and every asset could be distributed, one half to the survivor, one half to the deceased spouse's estate. Although in my mind, that's preferable. It's possible to, for example, if the Community Property Trust has a lot of assets, homestead just being one of them, allocate the homestead all to the surviving spouse's share, and then allocate property of equal value to the other spouse's share, so that you still meet the requirements of the Florida Community Property Trust Act, but you haven't divided all the assets on a one-half basis, pro rata basis. Again, the problem with that planning is that the surviving spouse may not get a double step up in basis on the Florida homestead, which is the whole point in doing this planning. So in my view, I would be very cautious with non-pro rata funding. Also, remember what we're trying to do is avoid the devise limitations on Florida homestead. And if we're trying to do that with non-pro rata funding that may happen literally years after the deceased spouse first dies, how is that consistent with existing Florida law that talks about vesting a protected homestead in the twinkle of an eye automatically at death? I think there's a lot of open questions there, unanswered questions. So that wouldn't be my go-to for avoiding Florida homestead devise limitations. Okay, and we just covered this slide actually, which is the effect on the double step up and basis of non-pro rata funding. All right, what are the issues tax-wise that come up with Florida Community Property Trust other than the ones we just talked about? Well, first is there is no direct authority confirming the tax treatment, the double step up and basis of property owned by a Florida Community Property Trust. That remains an unanswered question, and we could spend quite a bit of time going through the specifics of the tax analysis in support for Florida Community Property Trust, which I definitely support. I think that we do have community property under the laws of the state of Florida with these trusts, and therefore it should qualify, but that has not been confirmed by the IRS. There's many that think the IRS could challenge this new law and challenge these trusts, and if they did so, they would probably cite to the Commissioner v. Harmon case, U.S. Supreme Court case, in which a similar state statute was determined not to work, and an elect-in community property treatment that was allowed in Oklahoma was determined, that shouldn't apply for income tax purposes. And the IRS has indicated to us that they may take issue with Florida Community Property Trusts in their manuals, and they're citing to the Harmon case. So I would be certainly talking with my clients about the potential of these trusts not working as intended. I think, though, where the client may ultimately come to is, well, okay, maybe it doesn't work, although you think it does and has a very good chance of succeeding. Am I any worse off with the Florida Community Property Trust from an income tax perspective? And typically the answer is no. Under IRS Publication 555, the IRS has declined to comment on whether or not common law states with this new opt-in community property trust structure it is community property under 1014b6. Probably because they think it's too flexible and too good to be true. The time period for really knowing if these trusts work, I think this is an important one to point out to your clients. There's going to be some uncertainty even after the death of the first spouse as to whether or not there is this double step up in basis. And why is that? Because really it's not until the income tax return that reports the gain on the sale of the property that was owned by the Florida Community Property Trust on the death of the first spouse. Not until that return is filed and then the statute of limitations is passed on that return will you have certainty as to whether the strategy works. So, if someone dies this year and you report, sell right away, report as soon as you can, you're still looking at 2030 before there's any finality. Just because the higher values are disclosed or reported on IRS Form 706 or IRS Form 8971, that doesn't lock in the benefits we're looking for, unfortunately. The other note here would be, I would be coordinating with the client's CPA from the get-go, from the front, at the beginning of this transaction, to make sure that they're comfortable with your analysis on the tax side. They're comfortable filing income tax returns that report the double step up in basis. There could be preparer penalties to think through and things like that. So, you may even want to talk about what disclosures would be required in connection with the income tax returns that will be filed after the death of the first spouse to report the no gain situation to the IRS. All right, let's talk a minute about creating Florida Community Property Trust. The requirements are pretty straightforward. The Florida Community Property Trust Act does a nice job of outlining exactly what you need in your trust agreement to comply. It can be detailed, so make sure you do comply, but once you read those rules, it should be pretty clear as to what you need. For me, Again, I think that joint trusts are inherently more complicated than separate revocable trusts, and that's what most of my clients already have in place and are already used to. So typically, we're creating a specialized Florida Community Property Trust for the double step up in basis, get all the income tax benefits on the death of the first spouse, and then dissolve that trust and transfer the assets back to the spouse's revocable trusts. Is it possible to take an existing joint trust and update its provisions to comply with Florida's new Community Property Trust Act? Yes. And the law was recently clarified to make certain that's the case. Do note there's some very specific required language that has to be provided at the beginning of a Florida Community Property Trust. It has to be in all caps, and it does talk about making sure the clients have independent and competent legal counsel. An option that clients will have in creating Florida Community Property Trust is whether to make them revocable or irrevocable. We talked about my thoughts on that, and I think allowing each spouse to revoke the trust is the better strategy, and it avoids potentially some unintended gift tax consequences on funding. Also, I struggle with the concept of having a trust irrevocable that necessarily can be modified and terminated by the surviving spouse. So while it's possible, I don't think most Florida Community Property Trusts will be set up in that way. We talked about making sure that your clients don't have an existing marital agreement. You wouldn't want the Florida Community Property Trust terms to conflict with the marital agreement or potentially have those trusts being something not permitted under the agreement. This is an important slide. Florida Community Property Trusts are subject to challenge. And if spouses are getting divorced, for example, and challenge the enforceability of these trusts, the things they're going to point to are the things that they would point to for the challenge in connection with a marital agreement. And those issues, the things that would make a Florida Community Property Trust unenforceable are set forth in the code in 736-1512. One that I wanted to point out to you is lack of financial disclosure. So if you're doing these Florida Community Property Trusts, you do need to read through the ways in which they can be challenged, and you will need financial disclosure, or if not, you're going to need to obtain waivers. Essentially, it's all the same requirements of a postnuptial agreement. That's how I view them. So if you know what's required to have a valid and enforceable postnuptial agreement, you'll take that same knowledge base, those same best practices, and apply them to your Florida Community Property Trust. As I mentioned, there are issues for when you have the same lawyer representing both clients in establishing and funding a Florida Community Property Trust. That absolutely can be done, and I've done it, but you need to make sure that your married couple is totally aligned, has all the same goals and objectives, and that you've carefully walked them through all the pros and cons and risks of these trusts and potential conflicts of interest, and importantly, complied with Rule 4-1.7 and made sure that you obtain their informed written consent, because there are certainly potential conflicts of interest here. Our final couple of slides, in thinking through the different options that clients have under Florida law, here is a few of them, actually 5 of them, and I've compared them with Florida Community Property Trust being one, and then 4 other types of ownership structures that I've seen clients adopt. And I have a chart that walks through the differences when it comes to asset protection, asset management, what happens on the death of the first spouse, what are the gift tax consequences on formation, basis adjustment, estate and GST tax planning as well. Finally, here is what would be one of the illustrations, PowerPoints that I might go through with a client that would be thinking of a Florida Community Property Trust, to show them how the trust works, what are the key tax provisions, what are the key provisions that they need to understand as the married couple that's establishing this trust and it's going to be placing their assets into these trusts. Have it set up with, usually both clients are serving as co-trustees. Both clients are typically Florida residents, so I'm not worried about where they live. Again, homestead is one of the best use cases for these trusts. So I've done plenty of Florida homestead contributions to a Florida community property trust. And then I walk through the tax consequences, the steps that are required to navigate Florida homestead devise limitations. And this final slide, on the box here to the left, these are some of the documents that would be needed to complete a transaction with a Florida Community Property Trust and the transfer of a Florida homestead to it. And as you note, there's a number of documents that we would prepare. So these trusts can be involved and can take some time and therefore involve legal and accounting expense. So be sure your clients know what they're getting into. Again, these trusts can be highly effective. They can save a lot of tax for the surviving spouse, but you do want to make sure that your clients are fully informed of the pros, cons, risks, and that you as the advisor know about the tax issues and the pitfalls that can come up. And with that, thank you very much. Again, my name is Anthony Guettler. I'm with the law firm of Gould, Cooksey, Fennell, and I appreciate your viewing this video today. Thank you.